All right, so welcome. Today, what we're going to do is look at the document that I had you read for today because it's a legal document. I know that a lot of you kind of struggle with those sorts of documents. I'm going to try to walk you through it and make sure that you understand the important pieces of this argument. And the reason why we end here is because if you think back to where we started the class, and I said, there are a couple of things that I really wanted to bring out. One, I wanted to make sure that this wasn't sort of kind of high school history 2.0, and we were going to talk about some things that high school teachers are really reluctant to talk about. And one of them, of course, is gay history in particular, LBGT history in particular really doesn't show up in high school classrooms. So I wanted to make sure that that was in this class. But one of the other things we talked about was I wanted to bring out, especially with the films that we watched, about how history is often used in politics, right? That history was inherently political. And this case brings that out. Right. This case deals specifically with a case that originates in Texas. It deals with a law passed in Texas in 1973 called the Texas Homosexual Conduct Law. And basically, historians are getting together here to write this brief because it's trying to strike down a court case from 1986. Called Bowers v. Hardwick. And hopefully you saw that in the reading that you did in this document. And basically, Bowers v. Hardwick upheld a similar law in Georgia, a law against homosexual sodomy, and the court ruled in 1986 when it justified that law. It's one of the justices said that laws against homosexual sodomy had sanction in millennia of moral teaching. Right. And often, I don't know if you pay attention, but, lots of in our politics that people often say, well, it's always been that way. Or that's the worst thing that ever happened in history. And we make these sort of big claims, right, about something being unique or something just always happening and that being a justification for something. Generally, that's never true, right? And so basically what historians are getting together here is trying to push back against what we often do in politics, is justify something by just saying, well, it's always been that way. And that's what happened in Bowers v. Hardwick. And so in Texas, two men were arrested for violating this 1973 Texas homosexual conduct law. They're arrested for sodomy. And so the case, they get lawyers who, bring this case all the way up to the Supreme Court, challenging whether this Texas homosexual conduct law was constitutional. And lawyers get together basically to say that the legal standards here, the Bowers v. Hardwick, which had previously upheld this case by saying, well, it's really always been that way. We've always had laws against homosexuality and sodomy. These historians are getting together and saying that's not true. Right? And you can't justify this particular law by saying it's always been that way because that's not true. Right. And so that's the purpose of this, what we call an amicus brief. So it's the historian's amicus brief in Lawrence v. Texas. An amicus brief is also known as a friends of the court brief, which simply is there for if you're not an actual party in the case, you can write an amicus brief that makes your own sort of argument about how the court should actually rule, that brings your own sort of expertise and explains why you have an interest in the case. And so that's what's going on here with these historians. So I just want to walk you through. I've highlighted certain parts of this to hopefully if you were confused after reading this, I can walk you through and just kind of point out the really important parts of this argument and just kind of break it down a little bit. And so right from the start, if you ever read something and you see introduction and summary of argument, that's like that should be the part that you pay attention to the most, right? Where it's kind of outlining the argument. So let's break this down a little bit. So basically they're saying here is that they believe the court, they can best serve the court by elaborating on two historical propositions important to legal analysis, okay? And so one claim that they're making here is that, number one, there's been no consistent historical practice that singles out same-sex behavior as sodomy subject to prescription or subject to laws that outlaw it, okay? And two, they're arguing that government policy of classifying, discriminating against certain citizens on the basis of their homosexual status is an unprecedented project of the 20th century. Okay, and so what they're actually saying here is that, a lot of the laws against homosexuality that we've simply thought of as just natural or it's just always been that way were actually created very recently, almost surprisingly recently, right? They're a creation of the 20th century. And they say this Texas law of 1973 is an example of that, something created particularly in the 20th century. Right. And so this document is good for us to end on because it really gives us kind of a history of kind of discrimination against homosexuality, and that being something that's been kind of very recent. A very recent creation in terms of laws that have been actually created. Okay, so they say the first part of this argument is saying that there really has been no historical practice that singles out same-sex behavior such as sodomy, that outlaws it, right? And so what they do, this early part here, as you read it hopefully, starts in colonial America. Right? And so in colonial America, what the historians bring out is that, here you can see it highlighted, sodomy was not the equivalent of homosexual conduct, right? It was understood as a particular discrete act, not as an indication of a person's sexuality or sexual orientation. And so what they mean there is that if you committed sodomy, no one in your community really thought of that as changing your sexual orientation, all right? They didn't make you homosexual. And here they say, not until the end of the 19th century did lawmakers in medical writing recognize what they called at the time sexual inversion, or what we would call today homosexuality. The phrase homosexual sodomy would have been literally incomprehensible to the framers of the Constitution because that actual identifier, homosexual, just didn't exist at the time the founders were actually writing the Constitution, right? So the very concept of homosexuality as a discrete psychological condition and source of personal identity was not available until the late 1800s. Okay, because it's kind of a summary of their argument right here, right? So let's go down and let's look at each piece of the argument here. Okay, so they come back to Bowers v. Hardwick, that case that I referenced a minute ago. So the Supreme Court concluded by a 5-4 vote that the Constitution does not confer a fundamental right to engage in homosexual sodomy, right? And so it upholds this Georgia case that can outlaw homosexual sodomy. Okay. So then they go back and say the majority's conclusion was based in large measure on the supposed ancient roots of laws prohibiting homosexuals from engaging in consensual sodomy, and they say that's just not true, right? And so they outline here what the court's justification was. Okay, so now we come back here. So first, contrary to the court's assumption in Bowers, sodomy prohibitions have varied enormously in the last millennium, even since our own colonial era, in their definition of the offense and in their rationalization of its prohibition. The specification of homosexual sodomy as a criminal offense does not carry the pedigree of the ages, but is almost exclusively an invention of the recent past. Right. Prohibitions against sodomy are rooted in the teachings of Western Christianity, but even those teachings have always been strikingly inconsistent in their definition of acts encompassed by the term. All right. So then they go in kind of to these next paragraphs here, if you want to go back to them, kind of get into that inconsistency in the way that Christianity is referred to sodomy. And then it gets into colonial American statutes, okay, where they say here, those statutes variously drew on the religious and secular traditions and shared their imprecision in the definition of the defense. So of the offense. So again, this part of the brief here is basically going into the inconsistency in colonial American statutes about what actually constituted sodomy and what sort of punishments were actually available. Right? Then it moves into the mid-19th century. Most statutes define the offense as a crime against nature rather than a crime against God. So we get to the secularization here. Such statutes were still not the equivalent of a statute proscribing, meaning outlawing, homosexual conduct. Right? In 1868, no statute criminalized oral sex, whether between two men, two women, or a man and a woman, which often before that, in the definition of sodomy, it actually included oral sex often. And again, it was only beginning in the 1970s that a handful of states, including Texas, passed legislation specifying homosexual sodomy while decriminalizing heterosexual sodomy. Okay. And the important part here is that, when sodomy laws were actually on the books, it outlawed anyone from performing those sorts of acts. It didn't really specify homosexuality, they're saying here, until the 1970s. Another point that they want to make here is, despite the fact that there were laws on the books, even in colonial America, that outlawed sodomy. And again, sodomy meaning lots of different things depending on what colony that you're actually in. They say here, even though that they were actually on the books, they were actually rarely ever enforced. And they use, the trial of Nicholas Sension here as being kind of one of the rare times in which someone was actually prosecuted. But then they go in to say, well, this really didn't change the person's standing. The community understood as sexual transgressions to be a form of sinful behavior in which anyone could engage and from which anyone could repent, not as a sin worthy of death or the condition of a particular class of people. So it really didn't change his identity in any way, and there really were kind of very few consequences for the persecution in the first place. Okay. If we look at New York City in the nearly eight decades between 1796 and 1873, despite the fact that there were sodomy laws in the books, the number of sodomy prosecutions only increased in the last 2 decades of the 19th century. Excuse me. I didn't underline the first part here. So for instance, only 22 men were indicted for sodomy in New York City in the nearly eight decades between 1796 and 1873. But suddenly, in the late 19th and early 20th century, those prosecutions increased. Okay, and so what they're trying to say here is that there's really a shift in the late 19th and early 20th century in the ways that homosexuality was defined and also punished. So we get into the second part here, which is titled "Discrimination on the Basis of Homosexual Status Was an Unprecedented Development of the 20th Century," right? And again, that's something that if you really don't know anything about LGBT history, you might assume that that the status, the identity of homosexuality has just been there since the kind of beginning of time, but it's actually a pretty recent creation that historians have found, okay? So here it explains, over the generations, sodomy legislation proscribed a diverse and inconsistent set of sexual acts engaged in by various combinations of partners. Above all, it regulated conduct in which anyone, or at certain times and in certain places, any male person could engage. Only in the late 19th century did the idea of the homosexual as a distinct category of person emerge. That's really important, so I'll say it again. Only in the late 19th century did the idea of the homosexual as a distinct category of person emerge. And only in the 20th century did the state, meaning either the local state or federal government, begin to classify and penalize citizens on the basis of their identity or status as homosexuals, right? The states began to enact discriminatory measures in the 1920s and 1930s, but such measures and other forms of anti-gay harassment reached a peak in the 20 years following the Second World War, when government agencies systematically discriminated against homosexuals. And so the unprecedented decision of Texas and several other states, primarily in the 1970s, to enact sodomy laws singling out homosexual sodomy for penalty is best understood historically in the context of these discriminatory measures. The new sodomy laws essentially recast the historical purpose of such laws, which had been to relegate conduct generally, by adding them to the array of discriminatory measures directed specifically against homosexuals, right? So that's the big argument in this particular section, right? So let's kind of walk you through some of the evidence here, right? And so what begins to happen, they're pointing out here, suddenly, late 19th, early 20th century, we suddenly get medical organizations like the American Psychiatric Association that put homosexuality on its list of disorders. And that wouldn't be removed until 1973. Right. Some other evidence that they see here are anti-vice societies that were in our progressive era reading, that were organized in the late 19th century, opposed the growing visibility of homosexuality. We have the 1923, the New York State Legislature specified for the first time one man's, quote, frequenting or loitering about any public place soliciting men for the purpose of committing a crime against nature or other lewdness as a form of disorderly conduct. We have some more examples of regulations created here in the 20th century. New York State, the state liquor authority established after the repeal of Prohibition, regulations prohibiting bars, restaurants, cabarets, and other establishments with liquor licenses from employing or serving homosexuals or allowing homosexuals to congregate on their premises. California in the 1950s, the Alcoholic Beverage Control Board collapsed the difference between homosexual status, a state of being, and conduct, behavior, and suggesting that any behavior that signified homosexual status could be construed as illegal. And kind of keep on reading here. Simple acts such as random touching, mannish attire, limp wrists, high-pitched voices, and our tight clothing became evident of a bar's dubious character and grounds for closing it. And so those would be the actual acts that the people who were enforcing these laws would actually go to bars and actually look for to be kind of signs that a bar was serving largely gay men or lesbians, and it would be evidence for actually closing the bar down. They go on to point to Hollywood studios and censorship laws. We look at the federal government's role in prosecuting gay men and lesbians during the Cold War. We have 1930s, 1940s, 1950s, this sort of kind of popular stereotype of homosexuals as child molesters emerge. Examples of more than half of the state legislatures enacting laws allowing the police to force persons who are convicted of certain sexual offenses, including sodomy, or in some cases merely suspected of being sexual deviants, to go undergo psychiatric examinations. We go 1958, Florida Legislative Investigation Committee, which had been established by the legislature in 1956 to investigate and discredit civil rights activists, turn its attention to homosexuals working in the state universities and public schools. In 5 years, it interrogated some 320 suspected gay men and lesbians. So example after example of the 20th century, all of these sort of discriminatory provisions being created by particular states that weren't there before the late 19th and early 20th century. And then the next part of this argument gets into, what begins to happen after Bowers was actually decided. And so they're trying to create here a narrative to show the court that much has changed since the 1986 decision in Georgia in terms of Americans becoming much more comfortable with gay rights in the United States. So we have 1973, the American Psychiatric Association voted to remove homosexuality from its list of medical disorders. That was a big shift in LGBT history. We have, under President Clinton's administration, 2 executive orders that lifted some of the federal discrimination against homosexuals that were put on the books. We also have examples, though, that, as certain states in the federal government are beginning to incorporate gay rights into its laws, we also have examples of backlash that we've read about already. So, for example, Anita Bryant, we've read about her resistance in Dade County, Florida, and she nationalized that. Remember the Save Our Children campaign that I talked about a bit in the lecture. One thing that wasn't in our readings, Colorado's Amendment 2, which were there to kind of overturn gay rights laws in states. And Anita Bryant was kind of a part of that that sort of campaign that spread around the country that tried to repeal any law that actually tried to give simple kind of civil rights to the LGBT community. And what they're saying here is that this 1973 Texas homosexual conduct law is part of that backlash to this growing gay rights in the United States in the late 20th century, right? And so this entire brief here is basically kind of showing you how historians try to intervene into our politics when our politicians and lawyers and judges really kind of misrepresent history and use that in really powerful ways. Right, either passing a particular piece of legislation or justifying a huge legal case that has ramifications for people. But it's just here to kind of hit home this idea that history is not simply just learning a bunch of facts, but it has kind of real consequences for people in the United States. Right, whenever we say that something has always been that way, what I want that to be for you is not just to remember Lawrence v. Texas, but for red flags to raise up in your head that that's probably not true, right? That's not an argument to justify any sort of political decision, right? Push people to have, a real argument beyond something like it's always been that way. And every time someone does use it's always been that way, that's often when historians step in and say, no, that's not true. And here it had a pretty big impact on this case in Lawrence v. Texas when the Supreme Court ruled to overturn the 1973 Texas homosexual conduct law in 2003 in Lawrence v. Texas. The majority opinion cited this brief, saying that Bowers v. Hardwick, that Georgia case of 1986, was wrong. That this idea that these laws against homosexual sodomy had the basis in millennia was completely wrong and was decided incorrectly. And that these particular laws that are on the books are of a very recent creation in American history. That number one, that even the term homosexual, the identity of being gay, is something that is very recent in American history. It's something created in the late 19th and early 20th century. And these laws, these discriminatory laws that were put on the books specifically for homosexuality, are something that's also a very recent creation.